All right, we are recording. So thank you all for tuning in, and thank you, Woody Mosten and Mark Baer, for joining us today and for a conversation that I'm looking forward to since you first suggested this one to me. We're going to be touching on the kinds of skills that professionals who do our work need, maybe particularly lawyers, maybe other professionals as well. But I'd like you, Woody and Mark, to share with us where this conversation started for you, how you met, and bring us right into it, okay?
Well, first of all, good to be back, Carl-Michael, and to have Mark here. Mark and I met where we did things a little backwards. I was giving an advanced conflict resolution 2-day course, and Mark was a member of that class, and then he took my 40-hour mediation course. And I saw from the beginning that Mark was as much a co-teacher as he was a student, and has a peacemaker from the bottom of his feet to the top of his head. And so I watched with great delight and pride as I've watched him develop his practice, develop his writing, develop his speaking to the point where he is a real leader here in Southern California. So Mark, I'm thrilled that you're here as part of our ongoing conversation with my friend and colleague, Carl-Michael.
Yes, thank you, and thank you both so much for inviting me to join you in this series.
It'd be interesting, Mark, from your take, your sense of how we met and where you have gone and your place in the peacemaking world.
You know, when I first was trained in mediation through Woody, I was very much of the mindset of what I think most family law lawyers, or most lawyers in general, and judges are with regard to mediation. I was very fixed on the fact that mediation needs to be evaluative. And if people are coming to a lawyer or to a judicial officer for mediation, they're going to those people because they have knowledge in the area of law and they want them to be evaluative. And I was very adamant about that. And while the course progressed, I came to realize that evaluative mediation is not necessarily the only way, and certainly not necessarily the best way to mediate. And I have since been doing a lot of research and writing on various facets of family law and mediation and collaborative divorce, and the way in which I mediate has changed over time. I've become increasingly disenchanted with the use of evaluative mediation in family law. So it's interesting that Woody had a certain, was teaching us certain skill set and tools for our toolbox, and I was a little bit more limited, and I sent him an email saying, I've increasingly discovered that the things that I learned so long ago from you that I didn't necessarily agree with, as I'm doing this more and more, I've come to the realization that you were in fact right, and I'm remembering things that I learned from you so long ago, and it's all coming back, and I've learned so much from you, far more than I ever realized.
Could I interpose here a question? I'm thinking some of our audience may not connect with the phrase evaluative mediation. If you guys could maybe do a sentence or two what you mean by evaluative mediation.
Well, it's interesting because for collaborative professionals, we should be aware of it as well. Evaluative, I think, has two aspects to it. One is the prediction and assessment of the substantive value of a person's position. And when I say substantive value, I don't just mean legal. For example, a legal evaluation really sort of says, oh, this case is pretty strong, or you'll do well in front of a judge, or I don't think that evidence could get in, or you don't really have a legal standing to ask for joint custody or sole custody, whatever the case may be. But evaluative could also be from the mental health perspective, where they basically say, well, you people are pretty high conflict, and therefore what you should be doing is not having too many conversations and keep everything very, very specific. Now that's evaluative from the mental health perspective. It also could come from the financial perspective. You just don't have enough money to do what you think that you want to do. Now that's evaluative, as opposed to, so could you maybe tell us how you're going to be able to meet all of your expenses with the income that you have? It's an approach, and it is a mindset. The second aspect of evaluative is often linked, but not necessarily, with being directive, as opposed to elicitive. Many of my collaborative colleagues have learned the walk of collaborative, but they're still very directive maybe of their colleagues, maybe of their clients, maybe of their staff, as opposed to more elicitive of finding out what is important for them. So actually, I'm going to, since you've got dual degrees and are as schooled in this as anyone I know, Carmichael, how did that overview sit with you, and do you want to add or subtract any part of it?
I think that's a pretty clear explanation of the evaluative approach, not just to mediation, but to just about anything. From my perspective, it is, in terms of its attitude, it's one of, I am the expert, and I'll tell you what's right for you. I will tell you what will work for you. I will tell you, I hesitate around what your chances are at trial, because I do think that's an appropriate evaluation for a litigator. I think it becomes challenging when it gets overlaid into the collaborative process or an other than evaluative mediation approach. I was wondering, now that we've laid some foundation on evaluative, if we could talk a little bit more. Mark, you were saying so much about what you were learning as having been different from what you had learned in the evaluative approach. And I apologize for cutting you off. I wanted to get that description out there for people, especially the ones who aren't professionals who may watch this. Would you want to begin to talk a little bit more about that other approach that you made reference to, other than evaluative? What was changing for you?
Well, the other approach is basically to get to the why, to help the clients understand the underlying fears and emotions and figure out what it is that their needs are in order to try to satisfy their needs, interests, values, and goals. And that, what somebody is entitled to under the law does not necessarily mean that is necessary to satisfy their needs, interests, values, and goals. It could be that they do need that, but it might sit better with the other party if they understood why they need that. And they may need less and they may need more. I mean, the reality as far as I see it is that everyone enters into relationships or marriages for different reasons. And I've seen in the 21 years that I've been practicing, I've seen people come into my office who don't even realize that they're entitled to certain things. Maybe that they accumulated some interest in a retirement account that their spouse accrued or whatever is going on. They didn't enter into that marriage with the expectation that they were going to have an interest in the retirement. They have that because the law says so. The law puts a one-size-fits-all situation where everybody is entitled to and has these obligations, but not everybody enters into relationships for the same reason. So why are we looking at what the law says people are entitled to as opposed to what people need, what their interests, needs, values, and goals are?
Yeah. Even the notion of entitled to or rights to, certainly I try to dissuade clients from those notions right from the start. Woody, I think you and I have talked at some length about this, about the notion of rights being almost sometimes it seems to me that the discussion of rights and entitlements presents almost a bait and switch air to the proceedings. And when clients come in and get their questions answered about what they're supposed to get, what they're entitled to, what their rights are, and by the time a settlement is formulated for the couple, almost nobody gets what they were told they were entitled to. So
yes.
Yeah, no, go ahead.
I'd like to actually talk about three aspects of what I just, what we were talking about. One is, what do we do when our clients and our colleagues start rights-based? Second, I'd like to talk about Mark's incredibly insightful use of the word why and how having a why approach might be something that we all can think about. And third, being a little provocative, I'd like to talk about how we can use the law in creative ways in the collaborative process. How's that for an agenda for both of you? Would that be okay?
Absolutely.
Sounds fine to me.
Okay. By the way, what I just did, as anyone in my training knows, is checking things out. That's an elicitive approach. And that when we're around the table, I always end the table with colleagues and with clients. I always think it's our responsibility to check out what we're saying with the people that we're with. And it's one of those skills that we're talking about that I think is transferable from process to process. I'm going to say something heretical now to some of my colleagues, my collaborative colleagues. When we get clients who come in rights-based and we have professionals who are rights-based, I think it's important that we be tolerant of the fact that they're rights-based and not necessarily needs-based at first. And the reason I say that is in my experience, very few of us like to be lectured. Very few of us like to be challenged when we're starting a relationship. So that I guess one of the first skills I would like to talk about is accepting people where they are, even if it's quote non-collaborative, and then using that acceptance with rapport and hopefully some trust to work with people from where they are to where they could be, as opposed to either rejecting them because they're right-based, or rejecting that point of view, which can cause them to be defensive. I'd like to first of all try that one on for size with my two colleagues, Mark and Carmichael.
Go ahead, Mark.
Can you answer that, Carmichael?
Well, I think it's an interesting one for me to try to address first, because I do I do take a kind of an assertive approach when when a client first brings to me the notion of wanting to know usually when they ask what their rights are, they've already had a discussion with somebody. So it's always entertaining for me. Are they are they quizzing me? Do I know? Or are they exploring to see if different lawyers will tell them different things they're entitled to? I do take the approach of trying to, right from the start, getting them into the notion of their needs are more important than what the statutes may say. That, and one of the questions I will pose to them in doing this, sometimes I do it in statements, sometimes I do it in questions, but I will ask them, if the statute said you were entitled to X dollars and you needed twice that much money just to pay the rent, would you be okay with the fact that the statute says that's all you get? And usually they say no, and I will tell them, and neither would I. Which is why I use this approach of collaborative practice, trying to work to make sure that what you need is what you get, and that what your spouse needs is what she or he gets, and what your children need is what they get. So I know some people will, I think where I will draw the line for myself, this is just my own practice, certainly not because it's right, just my style. I will tell them that I will intentionally try to dodge their questions about numbers and percentages for as long as possible. Do you have thoughts on that, Mark?
Well, with regard, for me, my perspective on it is that when I'm meeting, let's say, with a client, the reality is that I'm hearing only one side of the story. And even, if you're even a mediator is going to see both sides. So when I'm seeing just one, how is it that I'm even able to evaluate, because the facts might be completely different? And that doesn't even get into the aspect that I've raised in numerous writings of mine, which is that we're all human and we all have different backgrounds and life experiences, and those life experiences include trainings that we've had, readings that we've done, research that we've done, but it also includes our own personal life experiences and work experiences, etc. So if we all have those and they're all unique to us, then the mediator or the lawyer or the judge is going to make certain assumptions, have certain values, beliefs, biases, and they're going to very likely be different than the lawyers or the mediators, and therefore their credibility findings, their factual findings, the use of their discretion is going to be very much different. So I have seen so many cases where we've gone to mediation, it's been evaluative. The evaluative mediator said, this is what's going to happen in court. It fell out of mediation, and the result was 180 degrees different. So the reality is, unless you're having, and when I have had settlement conferences in court, which is That's what evaluative mediation really is. It's a settlement conference. When I've had settlement conferences in court, I have tried to see if I could get the judge that's going to do the trial to do the settlement conference, because then at least it's the same person making the factual findings, the credibility findings, the exercise of discretion, etc. But the reality is that a lot of judges won't do that. And now, at least in LA, they've just determined that you don't know who the judge is going to be, and it's certainly not going to be the courtroom that the case is assigned to. So therefore, there's no way to look at who the judge is in the courtroom your case is assigned to and go up to lawyers who litigate all the time in court and say, be evaluative as to what's going to happen in trial, because they don't know who the trial judge is going to be. So that's the first thing. The second thing is that if I'm dealing with, the example that I like to use is child support. We have a guideline program. Guideline program says if you agree that here's the data and here's the categories it goes to in the program, then everybody who's using the same program is going to come up with the same result, the guideline child support result. And the reality is, if the guideline child support result says that let's say the father needs to pay $3,000 a month to the mother in child support for 2 children, the father is very likely going to think that the mother's getting a windfall and not going to be using all that money to the rearing of the children. This happens all the time. Now, wouldn't it make more sense if the mother sat maybe with a financial person and figured out what the real cost of raising the kids is, including the additional space in the home and the additional utilities and the bigger car and gas and all that stuff, so that she could demonstrate that, in fact, it's costing more money than that to raise the kids? Because if she doesn't do that, then the father is going to be resentful because he's going to think she got a windfall. Now, let's say, for example, that she did, in fact, get a windfall, that it's costing $2,000 a month to raise the kids, but the guideline says it's going to be $3,000. Well, if we position her at the beginning by showing that she will get $3,000 in court, then she's going to want the $3,000. If she shows that it's costing her $2,000, I'm not suggesting that she not get the other $1,000. But the other $1,000 is not really child support. It really is a windfall. So what if mom said, since I'm entitled to $3,000 and I'm only really spending $2,000, what about if I segregated the $1,000, so now it's $3,000, the $1,000 into a college fund for the kids, and what about you, Dad, since that's really my money, what if you put an equal $1,000 into a client fund? Into a college fund. Now, I'm only getting the child support that I'm actually spending, and we're having $2,000 a month going into a fund. One is from me, and one is from you, Dad. If you don't do things like that, the mom's going to spend all of the child support that she gets, probably won't have money to spend on the child going to college, and the father will feel like she got a windfall for the entire term of the support and not come to bat with the child tuition money later. This has been determined in terms of the percentages of non-intact families and what percentage of the parents pay for college tuition. It's because they feel like they were giving a windfall. And if we do it this way, we're enlisting everybody. That's the difference that's the use of rights and entitlements and incorporating that into a needs and interests mindset, because you're using what they're entitled to come up with something that benefits everybody, because both parents should want to see money going for the college education for the kids when they get older.
It's interesting. Today I had a new client call me on the phone, and the client had been in collaborative, but it had fallen out. And someone had said to her, well, why don't you give Woody a call? Maybe he can get it back in a different way. And I asked her, so why did collaborative not work for you the first time? And what she said was, after her husband had taken some very strong positions, she wanted some comeback from her lawyer. She wanted a lawyer to kind of protect her and to advocate for her. And she said to him, could you advocate for me? And he said, in collaborative, we don't advocate. And when she was told that, she got out of collaborative because she felt like she was being steamrolled. And what I said to her is really the point I'd like to make right now. A lot of it is style. A lot of it is nuance and process. And going back to elicitive versus directive. I have a feeling that what that collaborative colleague, and by the way, the lawyer is a colleague, and he's a good lawyer. But he had given a directive approach to a client as opposed to an elicitive approach. And what I had said to her was, I don't think any of us would lose our collaborative cards for talking about what you need and what you would like and how you're feeling, or in essence, advocating for you. But it's the way we do it. We do it in a more elicitive way. We do it in a way that will be heard, hopefully, by your husband and by his lawyer. And so it may be, if we go back in, that there can be another way of doing it. I'd like to hear your thoughts about that, Carl Michael.
The piece I heard in what you were describing is, certainly around the whole question of advocacy and what its role is. And the piece that the way I like to describe collaborative practice is it's about supporting the client. What is it that the client needs? Now, the example you described, if the client says, why don't you advocate for me? Yes, I can see easily almost a knee-jerk reaction from even a very good, well-dedicated collaborative practitioner saying, we don't advocate in collaborative practice. I can understand that. And what comes to my mind, because of course I'm just sitting here hearing about it, I'm not in the moment, so it's easy for me. What comes to my mind is, as you're describing, an inquisitive response. What is it you need from me? How can I support you in this? As opposed to the knee-jerk response being, okay, if she says advocate, she means that she wants me to do all of the things that I took collaborative training and sat at Woody Mosten's feet, to learn how to not do. And for me, it's, some of it is just, I dislike things. I dislike when we talk in terms of let's change the words for the sake of changing the words. There's nothing wrong in my mind about advocacy within the collaborative practice approach. If everybody knows what you mean when you say advocacy, so that for me, I prefer to just ignore that word and talk in terms of support. And that's what I've stolen from you, Woody, frankly, is that constant notion of support for the client.
This term, advocacy, came up actually when we were having dinner, which is one of the reasons that we were talking about this, was I used the term, I said that there are certain skills that are transferable from litigation into collaborative. And I said one of those skills is exactly this. It's advocacy. But I said instead of using the advocacy to advocate for your client's rights and obligations and positions, you're advocating for your client's needs, interests, values, and goals. Now, my colleagues don't necessarily like the use of the term advocacy, and maybe I'm using that term improperly, but I'm saying that when we're litigating, if we're litigating, we're supposed to be conveying information to the other side and to the judge in a way in which they can understand where our client is coming from in terms of rights, obligations, and positions perspective.
Yeah.
So when I'm using the term advocating in collaborative practice, I'm referring to our skills at being able to express to the other party and their attorney and just the others involved in the process as far as why that is something that our client needs. And if we're not good at expressing that, then there are going to be problems.
Mark, I think your point is a very, very elegant and an excellent one. And one of the things you asked Carl Michael are what are some of the transferable skills? What are some of the basic skills? I think I'm going to be able through this discussion at least to put one on the table, and that is and the best collaborative practitioners that I've worked with, and I love it. It's almost like a symphony when we're working in a good collaborative case or training. But the let's keep it a case. Let's keep it at the practice level. Is when my colleague is a lifelong learner, is really interested in what we all have to say. I call it in my trainings the Columbo approach, where he sort of scratches his head and he says, I don't know really which way to go. I don't know which way to go from here. Why do you think we should go that way? Or why do you think we should go the other way? And instead of being reactive, directive, and sometimes argumentative, that we stay on the side of dialogue as opposed to, and we've talked about this, Carl Michael, to dialogue which comes from an I statement, and it also comes from needs, and it comes from interest, as opposed to a debate, which we know what a debate is like. It's where we have a count and counterpoint, and they come together, and that's how we were all. That's those of us with legal educations. We were taught to do that and taught to do it well. And then we go from debate to discussion, which calms things down, but it's still point and counterpoint often, to mutual interests and mutual points, to that of a dialogue, and then even more so toward a sense of learning and lessons that we all can learn. It's that continuum that the best, in my view, the best collaborative practitioners are on the last part of it.
A piece of that struck me while you were describing it was the element of, and going back to your comments as well, Mark, the element of persuasion that is part of the usual parlance of advocacy. And my own perception is that the skills in collaborative practice that are best used are those of inquiry and clarity. That is a piece we're certainly very good at, is simply describing accurately, clearly, what the impact of a certain proposal is going to be on both parties. One thing I wanted to, when you were describing advocacy, Mark, shifting it from advocating for rights and entitlements to needs and interests, the added piece that I always include when I'm when I'm doing a training for, trying to transition attorneys, especially who are used to advocacy, into the support mindset. When I do use the term advocacy, I make explicit reference to I am advocating for my client, to my client, that it is in his or her best interest to work with the other client. That is a strong piece of advocacy that I believe I do retain in working in a collaborative manner, because that is a point at which a client may say, what's the benefit to me of working with this other person? And then I have to bring my advocacy skills out. I have to use their exploration of their needs and interests, and especially their aspirational goals, and how working with the other client actually benefits them.
I can feel Mark wanting to say something, so I want to have him join in.
No, the only thing that I wanted to say was that when I was in a course recently at a collaborative conference, they were talking about this term interests, and it's a very vague term. So, while we use it and I use it, it really is needs, values, and goals. I mean, what exactly is an interest?
Mm-hmm.
How do we define what an interest is in terms of how the client needs it? They could say anything is an interest. So I think it's more needs, values, and goals than interests. I think interests came about from what I learned from the class back in the day when they were talking about interest-based negotiation. But what is an interest?
Well, your point actually that you made before, I think gives us the clue. When you said, I want to be why-based, WHY. To me, that is one of the skills that a good collaborative practitioner of any discipline has. That when we hear, whether we call it a position, whether we call it a statement, whether we call it a piece of advocacy, if we just go to, in our own sotto voce, in our own minds, with our soft voice, we say, why? And then we turn it around and we say, I'm very interested in that. Why are you asking for it? Why is it important to you? Why should my client do that for you? Why is that important? And when you translate it to why, you begin to uncover the interests, however you define them. I find that it is two things. Number one, it's very effective.
Right.
It is an efficient way of uncovering what a client, what a party really needs. But even more importantly, it is easy to work with and easy to hear. I was having breakfast today with one of the finest litigators in Los Angeles, who was a classmate of mine at UCLA. He was number one in the class. He's just had one big success after another in the litigation world. And one of the, and he's with a very well-known firm. And we were discussing why it was that he's had the success. Actually, I was asking. He's too modest to ask. And what I said to him was, you get along with all of these litigators. You've got broad shoulders and a soft voice, and everyone seems to get along with you. That you're not always in fights over process. You're not in fights over strategy. You're not in fights with your colleagues or even the other side. that you are, in a way, you are a peacemaker. And he's in the litigation world. And it turns out that I think the joy that we have of our colleagues in trying to find out why from them and why from our clients may be one of the skills to take away from this conversation. I'm just wondering what either of you think of that.
No, I think it's great. And in fact, I was in a panel on peacemakers marketing, because apparently not all of us are so good at marketing the peacemaking industry. And Diana Mercer was talking about the fact that the three of us who were on the panel together all had different whys in terms of why we moved into the peacemaking field. And it doesn't matter why each of us had different reasons. But what did matter is that we did understand what our why is. Because if you don't, some of us are in the peacemaking industry and we never really sat to figure out what our why is. And if we don't know what our why is, then how are we going to be able to transfer clients into the peacemaking arena? Because we don't, or at least with us, if we can't convey to them why we're in it, then how are we going to convert them?
Yeah. You raise a great point there, Mark, not only about certainly about the core issue, the challenge of marketing as a peacemaker, which I've encountered a lot of people struggle with. But embedded within that is, you made the point of, if we don't know our why, and what I wanted to build on from that was part of you getting to know your why involved, it was likely not the only source, but part of you getting in touch with and being to express your why was the fact that somebody asked you, gave you the opportunity to express it.
Beautiful.
Yeah, and I'm thinking of it in terms of when clients come to us, frequently they have not been given that opportunity. They have not been asked, why do you want this? Many times they've been told what they should want. They've been told what to demand, what to expect. But no one has even asked them why. So I think that's, this mindset, and I want to expand just a little bit on that one, but this attitude of inquiry is essential to doing this kind of work, to doing peacemaking, certainly to doing collaborative practice. And just a parenthetical, a footnote, it is not the question. There's no magic in asking why, because you could ask why and have it completely derail the entire process and offend whoever you're questioning if your attitude is not one of inquiry, but instead one of challenge.
Exactly.
So it's really important to know, I like to emphasize to people, it's not the magic of the question, the magic is the attitude of inquiry. Do you really care what's important for this person? I've always suggested to professionals who want to do this kind of work, consider starting with the longer question as opposed to the short form. Rather than risk the why, ask the variant that you both use. What's important about it for you? What is it that you value in this? The other similar questions that I know you guys are familiar with. If you were to get that, what is it that it would mean to you? What would you have if you got that? Those kind of things. But it's a skill that I know you both are saying the same thing. It comes from attitude more than anything else. You have to be genuinely interested in what your client needs.
Well, do you mind? What I was going to say, and this leads into another skill set that I was saying is important and transferable, which is if we can't figure out, or our client can't figure out, we can't get to the why with our own client, then we might not have good client management skills with our own client. I mean, client management skills is much bigger than getting to their why. But what I was discussing with Woody was that in litigation, we're not trained as lawyers to have client management skills. That might be more of a psychological thing. But in litigation, if we don't have good client management skills, what happens? I mean, the case just drags on longer. We make more money and it goes to court. But when you're outside of the default process and you're in a mediation or a collaborative process, if that lawyer did not have good client management skills in litigation, what makes them all of a sudden think they're going to have good client management skills in collaborative? And if they don't, then aren't they sort of a weak link in the collaborative team or on the collaborative team?
Bunch of questions in there. That last one is, I think, one of the questions that adds to the value of the collaborative practice approach, because the weak link is not the weakest link on the team is not the break point, because the rest of the members of the team, even if it's only the other attorney, can support that other professional who may be challenged in this. I was holding back as you kept making reference to client management skills, and from my own litigation background, I was remembering the kind of things that were being talked about as client management skills, and I don't think that's what you mean. So if you could expound a little bit on that, I think it would be helpful, especially in terms of, if clients are actually watching this, what are we meaning when we say client management skills?
What I'm referring to in a collaborative setting, in a client management skill set, is if the lawyer is not able to express to the client the best alternative to the negotiated settlement, for example, and the worst alternative to a negotiated settlement, the client might run for the pavement and go back into litigation. So if the lawyer is not capable of translating that into something that the client can get, then I think that the lawyer is lacking in client management skills. Now, other people may use different terminology for that, but that's what I'm referring to, among other things, in client management skills. What I learned a long time ago is that there are many people who are at a certain thought level, and they convey information at a level that's similar to theirs, but they can't convey information to educate people who aren't necessarily at that same level. And if you can't convey the information, then your client's not getting it.
Okay. So you use the word again. Describe what the client gets, or does the client get it? You're not talking about what they receive. You're talking about, do they understand you?
Correct. If you can't get the client to understand how this is benefiting them, then they're going to run for the pavement.
And Woody, your perspective on this. My thought is always, it's my job to speak to the client, to find out what the client understands, and part of my role is to translate all the legal gibberish into the client. Your thoughts on that kind of thing, that element of the.
I agree with you, underline and in bold, and I want to refer to something that means a lot to me. There's a website called www.brownmosten.com, and that is the website of the International Consultation Competition. It is a law school competition that has criteria and teaches law students how to talk with a client. And there are a number of criteria. If anyone goes to that website, the link is Judge's Assessment. And I just want to talk a minute about this because it's a little off topic, but it's very educational. First of all, in this law school competition, which are training future peacemakers, and I believe client consultation and counseling is the foundation for our work, a complete foundation. There's a seminal book, and it's by actually a mentor of mine, by David Binder, Paul Bergman, and Susan Price, called The Lawyer as Counselor, a Client-Centered Approach. And if any of our colleagues have not read that book, I'd really highly recommend it. The assessment criteria of the competition, of the client consultation competition, also should be viewed in essence of who are the judges. It's an interdisciplinary. It has been since it started in 1969, but the international started in 76. It's interdisciplinary. So on every judging panel, you have a lawyer, you have a counselor, and usually a teacher of the skills. So, but sometimes it's two lawyers, but always a counselor of some sort. Sometimes clergy, sometimes a psychologist, sometimes a social worker, sometimes a school counselor. And these law students are taught, and they are really good. You can see on that website, they have a video, and you can see how excellent they are as counselors. It's what we can learn from. So I guess my answer to you, Carl Michael, is yes, this is what we should be doing. And yes, there is a lot out there that we can learn from in bringing into our work skills that are transferable in the various processes that we're talking about, so that it's the support of the client, which is the essence of what we do.
I wanted to shift gears because I'm mindful of the time. We're moving on to the hour. I hesitate, but I'm just going to make reference to the conversation we had last time. And I think what we're talking about here, especially in connection with how we communicate with the clients, is a critical element on the topic of informed consent versus, as I've shared with you, my notion of overwhelmed acquiescence being vastly different from actual informed consent. And I think developing these skills in ourselves, how we communicate, is essential to actually getting genuine informed consent. But what I wanted to do in the time remaining is maybe bring us back a little bit to that, to an earlier question. We've talked about the why attitude and the peacemaking thoughts, and maybe get some thoughts on the challenge that we made reference to early on of, okay, I'm in the process and the other professional isn't as fully developed in this area as he or she will be. What do I do?
I actually had a instance last week that I want to relate, but before I do, since we don't always have the benefit of Mark in these conversations, I'd like to defer to Mark and have him start to answer it, and then maybe I'll finish with my little story, and we'll take it up in our next conversation, Carl Michael.
Okay.
No, I mean, if I have counsel who is looking at things from a rights and obligation standpoint and they don't understand it, it's true. If you start to educate them or lecture them, they're going to shut down. Mm-hmm. But again, it's the same thing. You ask them what it is that they think is going to happen. You know, when they say, this is what I want or this is what the client's entitled to, you have to also get into what makes them think that the judge is going to make these findings or that finding, and all of these things need to happen in order for them to get that. I've seen this happen all the time. Most recently was when I was volunteering as the mediator at one of the courtrooms or courthouses, and I had opposing counsel telling me this stuff, and I said it was on an attorney's fees contribution, and I said, you're in front of the same judge that you were in front of before, and you know what the judge did that time. What makes you think that if you go in front of the judge this time, it's going to be any different? You're in front of the same judge with the same type of situations. You know, sometimes they're just, maybe they had too many other cases. Maybe they're just not recalling exactly what happened in court until you start asking them why. Because when I asked them why, it's when I determined that they didn't get what they were looking for in terms of the attorney's fees the last time they'd asked for. So when you start to get into the underlying reason, you can get them off their why. It's basically an analysis. You get them to do their own analysis by asking them questions and conveying information.
Well, I don't know if I have time for the whole story. Okay. So maybe we'll do the story next time. I'll just set the story up. As many of you out in Webland know, when I'm mediating, one of the things that I try to work with the parties to do is to engage collaborative attorneys as their counsel, as their consulting lawyers, and have those collaborative attorneys sign a participation agreement with the disqualification clause. So everybody in the mediation, lawyers, parties, ancillary, are all with both feet inside the mediation room. And one of the parties fired his lawyer, but still wanted to stay in collaborative, so didn't yet terminate, but we were one lawyer down. And he brought in a new lawyer whose first statement was, I can't sign that participation agreement. I want to be disqualified, but there were things that were in that agreement that I need to renegotiate. And so that's our story for next time that we'll start with. And I have one quick answer, and we'll know tomorrow. It's called lunch. And I've invited the two lawyers, the one who was on the case, whose client was about to bolt when the new lawyer came in, and the new lawyer who's come in who wants to renegotiate the participation agreement. And I invited them in for lunch. They both have accepted my invitation. But the first thing we're going to start with is a trust-building conversation between them, so they get to know each other a little more. Because when they get to know each other, they're going to like each other. And I have a feeling this renegotiation is going to be about 4 minutes long, and we're going to get on to the other issues that we have. So thank you, Carl Michael. Thank you, Mark.
Thank you both. Thank you both. And thank all of you who are listening out there. And I'm going to end the recording now.